The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to today's webinar, Successful Separations, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will try to work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenters will be answering questions throughout the presentation. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory Preventing Harassment training in English 3 times a year. With that, let's begin today's webinar, Successful Separations. Today's interactive session will be facilitated by CJ Westrick. CJ Westrick is an SPHR and has been in human resources management for over 25 years and received her Senior Professional in Human Resources National Certification in 2002. She started HR Jungle in 2006 and targets companies that want senior-level HR expertise on a part-time basis. HR Jungle provides business owners and management teams workable solutions and hands-on assistance with employees and legal compliance through outsourced HR services. Welcome, CJ.
Thank you, and welcome everyone. So, successful terminations, or separations, it kind of feels like we should have had this about 3 months ago, right? And today what we'll be looking at is understanding the various employment relationships and identifying the employment laws that can affect terminations, to recognize legitimate reasons for terminating employees, and how to prevent wrongful discharge and discrimination lawsuits. And with that, we're going to jump right into our first polling question. If you're saying anything, I can't hear it.
Thank you, CJ. Okay, so if you have an employment at-will relationship with an employee, you have an absolute right to fire that employee at any time for any reason. Is that true or false? And I typically like to see about 80% of the people voting, because I know some people are sharing screens, so we won't ever probably get 100, but we want to make sure that you're involved in this, so please vote. If you are using a tablet and you can't get to your voting buttons, tap the screen first, and then the options bar will appear, and then you can vote. So CJ, on this one, we have 44% say true and 56% say false.
Well, it's an interesting question these days. I mean, you know, a lot of states have at-will relationships, but it also technically feels a lot like lip service, to where, yes, the law says that, but you really do want to be able to give a reason. And so, but the law, if you have at-will laws in your state, it does absolutely say you can fire some, either the employee or you can end that relationship at any time for any reason. But I would just say always be careful if you just jump into it like that, because the lawsuits pop up when the employee doesn't feel like they were given a valid reason, and or no reason at all. I find that they end up making up interesting reasons. All right, so employment relationships. We have I've got clients that call them employee contracts or employee agreements, and these are something that typically will outline very specific things about the employment relationship. Usually, I only like to see those used for top executives, because you'll see that like with the C-level, where there might be a built-in severance agreement in there. There might be other things. But I see them used for a lot of other levels of employees, and I'm not so crazy, because often they'll have everything from like a job description thrown into that agreement to things that may end up conflicting with what you have in a handbook, and it gets messy. I prefer, to keep it simpler with an offer letter that's just very succinct and about the, the job offer itself. There's employment at will. Like I said, it's a common law doctrine, and that you're supposed to be able to, terminate at will. But I do think it's to be used with caution. There are times you want to use that, but I think it's easy enough to find a legal reason that's simple that you can use as a valid reason, and not just say, oh, you're at will, you're gone. We also have what's considered the psychological contract. These are the unwritten expectations that either the employee or the employers have about that relationship. And I see it a lot with employees where they're in an interview process. They're told something by, I've had everything from a VP tell that interviewee something that then we were held to because it came from a VP. And so I'm not crazy about having something like that out there, and that's part of the training process for anyone who's doing, the conversations with employees, and to know that you can't just throw these things out there and not expect it to pop back up. Let's move into our next polling question.
Okay. 2 federal laws that impose limits on termination are the Civil Rights Act and the Fair Labor Standards Act. So that, I think, goes directly in line with a question that we've already received. And I'll just ask the question, what if the reason given is in conflict with federal discrimination laws and connected directly with discrimination against a protected class? So I think that's exactly what you're going to be talking about as the introduction to this question, right, CJ?
Well, there are certain protections on there, and that's where, you have to take a look at it, because there are times when I have told a client, or when I worked inside a manager, and it's like, that's not going to work. You need to have different reasons, and I'd rather it not be something where you're just papering the file all of a sudden. So it's like, it's good that that's the reason they want them out. It's not a good reason to terminate. So now you need to figure out and maybe do a little more work with this manager / employee and figure out what can be done here to end up either giving you a legal reason or to make that relationship work, because that is dangerous ground indeed.
Right. So we only have about 57% of the people voting. I'm going to encourage people to put your votes in so that we can make sure everybody's staying engaged here. And CJ, on this one, we have 86% say true and 14% say false.
It's definitely true. In fact, there's a lot of different protections when it comes to terminations. So you need to figure out which ones, just like the person who asked the question, you've got to figure out, you've got to know the laws and understand where those protections are depending on that particular employee. Because any one of these things that are listed could certainly pop up in there. American Disabilities Act has become more of an issue, everything from the COVID and things like that. But there's a lot of little things in there. If you don't have something that's a very straightforward, talk with an attorney, someone who knows the labor law in your state, because it's important that you make sure that you're not bumping against something that you're just not familiar with. I know if I've got someone who's out on a workers' comp leave and they, wanted to terminate, and it's been like a long time that the person's been out and stuff, I still won't do it without talking with an attorney just to make sure there's nothing I've forgotten in the process, or that there's not some other protection I need to worry about, because the ADA has lowered the bar considerably for what qualifies with them. And so you need to be careful to realize that these might be protected in some fashion. So you always want to know what's out there first. And geez, we're just popping through our polling questions here.
Okay. So, before terminating an employee for poor performance, try other possibilities such as verbal counseling, training, written warnings, or all of the above. And we had a participant ask if we are going to receive a copy of the slide deck. And I just wanted to let everyone know that all of the webinar materials we discussed can be found at the Aspen Heffernan webinar website, and I will be sharing that URL in a follow-up email. So don't feel like you're missing out on it right now. You'll get a copy of it later. And we have a lot of people voting this time. Thank you so much. We have 71% already. So CJ, we have 0% say verbal counseling, 1% say training, 0% say written warnings, and 99% say all of the above.
It really is all of the above. You want to make sure you've covered your bases when at all possible. And so let's talk a little about some of those potential reasons that you might want to terminate. It is possible. I mean, I have, unfortunately, a large number of clients that I've talked to, and even just prospects and stuff, where they truly believe that if they fire somebody for poor performance, they won't get unemployment. Now, unemployment is usually pretty easy to get, and poor performance, unfortunately, is not one of the reasons they don't get it. So, you know, it's more, there's statistics. I used to have like this whole chart, but I lost it somewhere along one of my moves, and about the cost of replacing an employee. And so when you look at somebody who's giving you poor performance, it really does have a financial impact, and you need to look at the reasons for it. Is it because you hired somebody who didn't have the skills that you needed for the position? Is that supervisor or manager a poor trainer as to what they want and aren't clear about their expectations? You know, there's a lot of different things you can do with poor performance, but it's much less costly to a company to try and improve their performance first before you just terminate for that. And of course, document, you're going to see this a lot, document what you're doing, because there's nothing, I have terminated a lot of people without any paper in their file. But I really dislike that because it's so easy to put some paper in their file. You have a conversation, you write up a quick note, stick it in their file. It's not difficult, and it's one of those huge training issues with managers that you need to go through and try and convince them of the validity of it. Another thing that people get fired for is insubordination, but you need to be able to define what that is. California Unemployment Office has actually described it to me, and I was laughing, and they basically say that if an employee is in your office with the door closed and saying all kinds of terrible things to their manager, it is considered voicing their opinion. However, if they do that same thing out in front of other employees or customers, now it becomes insubordination. So recognize that difference, and but you have to also recognize what each person thinks it means, because it can be very different. You know, some people just think, oh, I just lost my head for a moment and that was it. But you're looking for true insubordination, that whatever you were expecting them to do, was in fact fully told to them, so they understood it. It wasn't illegal. It was important to you. It was, something that they were required to comply, and the insubordination was intentional. So some of those things are hard to prove, but I have actually, and the only thing it's going to help you with, if you don't have all those things, in fact, is maybe to fight unemployment, but not necessarily a lawsuit. So you want to make sure, if you're using insubordination as a reason, that you really understand what that means. And overall, it's you're going to be looking at, what kind of offenses were part of the insubordination, and again, what are your alternatives first? Is it just the fact that there is complete misunderstanding of what was expected of the employee? Because I find that happens a lot. Supervisors, not necessarily across the board, but a lot of people in general have a hard time clearly expressing what they are expecting from an employee, or they never state it at all. And then suddenly that person's not doing it. They're doing this over here. They're being insubordinate because they don't do what I want. And yet you find out the employee didn't actually know what they wanted. And so it kind of goes in a way, insubordination is kind of used and abused as far as a reason for things. And so it's more, you don't necessarily hear people spouting insubordination. You'll hear instead where a manager complained that the employee's never listening to them, they don't do what they ask, stuff like that. And but you have to kind of look behind the scenes on a lot of these things and figure out, is it just a miscommunication? Is it a lack of training? Depending on the size of your company, not only, usually I find mostly just large companies have a decent training program of any kind. A lot of smaller companies, it's like the person shows up for work the first day, they're shown to a desk and you're on your own. And so there's a huge gap in between there of what goes on when you're looking at everything from poor performance to not doing what you want them to do, stuff like that. Another reason is poor attendance and tardiness. And here, you want to make sure you've got a very clear policy, because there are different things now that protect employees in this area. And so you want to make sure first that they understand your reason. It's like a lot of employees will, let's say that you want them there at 8 o'clock every day and you're ready to write them up if they show up at 8:05. I found it's more effective if you are giving them a reason to be there at 8. If it's the front desk and people, that door gets unlocked at 8 o'clock, then yeah, there's a good reason for them being there. If they're the ones unlocking it and they've got employees standing outside because no one's unlocked the front door, then that's a good reason. But if you're just saying it's because I want you here, or you make sure that you're following that policy across the board, that it's not just picking on certain people who might be late. And the attendance is a whole nother kind of side to that, as to whether it's an excused absence, have they requested time off and therefore that's an excuse? Is it a protected time off? Like a lot of the sick leave laws, which would make it excused. The unexcused is when they just don't show, they don't call, and you're not sure what's going on with them, or that they don't have any of that excused time available because they didn't ask in advance. But you want to be careful to interpret and apply your rules reasonably and fairly. I always say it's like, if you're going to create a policy for one person, think mentally about the best person you've got in the company and what you would do if they were late. And if you're not willing to do it to that best employee, then you can't set up a policy just for that worst one. You've got to find a middle ground and document again. It's like I've got one client where she's calling the employee a trust fund baby, because as long as he has any kind of a job for any number of hours, he gets his trust fund check every month. But he ends up not coming into work at least 50% of the time. And so she is working on having something done with that. But it's like, there's different reasons people come to work and don't come to work. Oops, let's see, am I already there? Okay, yeah. So it's something all of these things, when you're talking terminations, you really have to explore what's behind it and see if there's an alternative suggestion for helping the employee follow your policies. Let's move over to number 4, and then I'll keep talking a little bit more about the attendance.
Okay, here we go. Provided the company can prove the employee had excessive absences and tardiness, the employee has no legal recourse against the company. Is that true or false? And CJ, we had one question come in regarding insubordination. Is a yelling employee considered insubordination?
It can be if they're doing it in front of others, because I had one where she was doing a company meeting and it wasn't a large company, it was only like 12 employees. And this one, just started yelling, saying this is ridiculous, blah, 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 and walked out. And she was fired for insubordination and did not qualify for unemployment because of that.
Okay, so there you go. Okay, we have 60% of the people voting. I'm going to wait just a second or two further until we get closer to 80%. So provided the company can prove the employee had excessive absences and tardiness, the employee has no legal recourse against the company. 39% say true and 61% say false.
I think it's hard to say these days that an employee never has legal recourse, because there's always attorneys out there who will try and give them some kind of recourse. But the first thing and the most important is to look again at the laws. The laws continue to change. There's a lot of states now, and even in California, there are now 30 localities that have different paid sick leave laws. So you're having to look all up and down California to see where are the people, stuff like that, to see what protections they have. And some of these sick leave plans are not well written necessarily. I know with California's, it's been a struggle because they tell you that the employee does not have to contact you like an hour before they would be due to come to work. They're supposed to contact you as soon as practicable, which is a phrase I do not like because the attorneys have told me that could be 3 days later. That's when it was practical for them. And as long as, because I've had discussions with attorneys, and, I've got clients in handbooks where we've got job abandonment policies that say if you're a no-show, no-call for, I've got some clients that have it at a couple that have it at 1 day, most are at 3 days, and then they start termination proceedings. And the attorneys have told me it's like if that employee comes back on day 4 with a doctor's note, which is the California law, then you have to reinstate them in the job. And so, you want to be very careful with the different leaves that are available for them, or the different laws that protect absences and what they say about it, and to find out whether or not it's something you can deal with. And the easiest thing is obviously when there's no medical relationship at all with the reason for the absences, because there's just so many different things that can pop up on a medical basis. But you do need to document this stuff. Keep track of these things. Keep track of if you've got, a paid sick leave law. Keep track of what the timing is on it, because I've seen some clients where they're not tracking the sick days, and then they finally decide the person's been gone so much, but now they're still showing that they've got the full load of sick days if possible. And so you can't, you have to follow through with whatever you implement and make sure you're tracking it, or it works against you in the end. Make sure, whatever kind of policies you've got, that you're really doing some training on it. Just handing out a handbook isn't really sufficient to look at, what you're doing. You need to let your supervisors, your managers know how to deal with this stuff. Some of the worst things that can happen is if a manager wants to fire somebody because they're gone, and you find out they were eligible for FMLA leave or something like that. And so everybody needs to be trained. The employees need to understand how your policy works. If you've got like a paid sick leave, especially if it's got state law behind it, then you really need to understand how that works. I found out, that we can't limit the amount of sick leave, even though the law does, unless we have a written policy in California. And so it's like, does your state law have some little weird quirk like that in there to where you've never bothered to write it up because it's a state law, but you didn't realize the state law didn't quite go into the level of detail needed to be able to use that as a reason for terminations. And, so you want to kind of look at that, but make sure everybody understands that you can't just terminate blindly without having a reason, that works, and that there isn't something that would protect that employee, because there's so many things out there these days that can, and the protections seem to get added more and more. And depending on your state, there's some states that don't have much in the way of employment laws other than what the federal government puts in place. But there's other states like California that is excessive in their employment laws. And so that's a state where you have to be very careful. And it's not just whether or not your company is located in that state, it's where the employee is working. So keep that in mind. We've got at the moment a lot of people working remotely because of COVID. And so if you've got people who are, I've seen where some people are like going home, shall we say, to another state to work remotely while COVID's going on. And suddenly you've got to think about the fact that now that employee's subject to the laws in that state, not just where they were working before in your office. And so it can be a little, you know, mind bending sometimes to think about all the what ifs, but some of it's just laying it out clearly and understanding what it is. If you're going to have remote, recognize what that does. If you're going to, you know, have an attendance policy, make sure everybody truly understands it and that it's followed, because it doesn't matter what you've got in writing. In the end, where the court's going to look at is what your practice is. So if your practices don't match up with your policies, you've got a whole nother issue going on there. And some of the policy violations that can happen that cause terminations are, you know, standards of conduct. This is where maybe you've got the yelling, you know, the insubordination kind of fits into here. And sometimes it's the dress code, that you've got a dress code that the employee is not adhering to and refuses to. And you've got now a lot of states are putting in the abusive conduct, which is considered like bullying and often part of an harassment policy. Harassment itself, what qualifies, what doesn't, you know, is someone, you know, harassing protected character, you know, or harassing based on protected characteristics? Are there alcohol and drugs involved, and what is your policy? There's a lot of states out there that now have recreational marijuana laws, but you have to understand how that fits in the workplace. Right now, marijuana is still on the federal list of prohibited drugs or illegal drugs, and so you're still able to have a company policy that says absolutely no medical marijuana even. And it's still kind of unclear because we can't test other than for positive or negative on that, like we can with alcohol, to see what level they are to find out if it passed the level that's not allowed. But you kind of want to be clear not only on what your policies are, but then in applying violations of them. You can't have somebody that, you know, did something wrong that didn't get written up and try and fire somebody else over here for pretty much the same violation. So again, look at that, look at what the appropriate consequences are. Maybe it doesn't mean that they should be terminated. Maybe instead it's like it's a write-up or a final warning based on that particular thing that happened. But, you know, look at, it's like I've seen companies where they want just about everything in the handbook to follow up with a statement saying, and you could be fired for this, for not adhering to this policy or that policy. And it's like, and at a certain point you kind of know, okay, that's a given, but you also want to make sure that it's a fair policy, that it's not something that's next to impossible to adhere to, or that you really aren't doing it across the board, so that you can say that there was no discrimination in how you applied your policies, because that's where it comes back to, you know, kick you is when you kind of someone can prove. And employees are surprisingly good note takers. They, you know, while it might be hard to get your managers to make notes in the file, the employees, if they're feeling the least little, you know, harassed or picked on in any way, they start taking notes that are very well documented, more so than what the company usually has on their side. And so this is another reason it's like you figure out a way to train your managers and your supervisors to make notes. And to me, you know, making notes is this, do it in the simplest, easiest manner you can. I mean, it needs whoever's writing it, you know, their name and date on it, and full names. I've gotten notes from employees before where they're complaining about something and it's like, well, Sam did this and Joe said that, and it's like, okay, I'm the consultant, so I don't necessarily, depending on the size of the company, know everybody's name or who they're working around. And so I'm always having to go back and say, write full names, because a year, 2 years down the road, nobody's going to necessarily remember these people. And now you've got a worthless piece of paper in your file. So make sure that, you know, they're doing it, but it doesn't have to be an essay. We're looking for like a short paragraph that's just very, you know, clear and succinct on what it is that happened or what they, you know, inform the employee about, so that you've got something, because there's nothing more powerful than coming back and saying, wow, you know, on January 3rd, we had a conversation about this. And then on February 20th, we talked about that. You know, that's very powerful when you're leading up to a termination or leading up to the fact that you may terminate based on this employee's behaviors. When you've got, I've had this happen where somebody, it was like we had, one of my clients had an employee who didn't show up for work. And ironically, it was the bail bondsman's office that called to say, I'm sorry, Joe won't be at work today. And it was, they found out, you know, who that person was, because it was obviously not Joe. And then, you know, the questions come up. It's like, well, what do we do? They've been arrested. Do we, you know, terminate them or what? And you have to find out. Bottom line is they have certain protections. If it was something that happened on their personal time, if they've not yet been convicted. Just being arrested doesn't mean that they did it. And so you can't assume guilt any more than the court's supposed to. So you need to kind of figure out, you know, if something like this were to happen, do your people know how to deal with it? You know, because it does come up occasionally. And, you know, so you have things that come up and you need to know how to deal with it. And some of it is you just ask the employee, tell us what's going on, you know, because sometimes they'll miss work because they have to go to court. And, you know, and you can ask certain questions, you know, kind of up to a point. You want to know, it's like, what happened? Are you going in as a witness? Are you going as an accused, you know? And, you know, the big thing really important to you is, yes, the time off work needed. And, you know, was it work related? Because there are some crimes that are work related. But time off work, if somebody's going to get a 30-day jail sentence, suddenly you're not wanting to hold that job for them. So you have to kind of look at that and just tell them, it's like, you know, I would probably just say, you know, if you've been convicted now, you're going to be in jail for at least 30 days. You know, it would be best if you resign. Otherwise, you know, we're going to terminate. But it's like one way or another, you want to break that employment relationship if once they've been convicted and you know they're going to be off work for a period of time and you just don't have any reason to hold their job for them. Moving into another polling question.
Okay, here we go. Lying about required credentials or work experience on a job application would probably be considered adequate grounds for termination. Is this true or false? CJ, we're not getting that many questions in today, so you must be doing an excellent job, and our audience probably paying excellent attention.
Or they terminated everybody because of the pandemic, and now there's no new terminations coming up.
There you go. So, and then I think we only have one polling question after this one. So we're about 70% there. So CJ, on this one, 91% say true and 9% say false.
It is true. I actually, you know, but some of this means that you need to put your checks and balances in place. Years ago, I was working inside a company, and one of our sales managers, it was an interesting thing because we were pharmaceutical, and there was a new sales rep who had been hired and, you know, had no previous pharmaceutical sales experience. And I remember, I mean, it's like one of those things where I remember her resume, or not a resume, her job application. She had listed this like Betty Bop's, you know, beauty salon she'd worked at for 3 months or something that was on there. Well, you know, she was hired, and 3 months later, we were doing a combined training with another pharmaceutical company to, you know, both companies were going to like distribute the same product. And one of their sales reps came up to my manager and said, wow, so you hired her, huh? Needless to say, some questions, because how did, you know, she apparently had worked for that company previously, but had not put it on her application or in her resume. And so when we were talking with her about this, she said, well, I was only there for like 3 months, you know, so I didn't think it was relevant. And, you know, my response was, but you thought Betty Bop's beauty salon was relevant versus another pharmaceutical company. And, you know, so she was, you know, trying to hide it. But I've also seen, you know, and we did terminate her, but I've also seen where a judge has actually said, like on, if you don't bother to do your due diligence when hiring, And let's say 6 months, 9 months later, you find out that they did something, they lied on the resume. Because or not the resume. The resumes always have lies. They lied on the application because the application is the one thing where they're supposed to be saying, I'm being honest here. The resume, do not believe everything that's on there. There's 70% have, nicely we'll put it, lies and omissions, or errors and omissions is the way we phrase that. So anyhow, it was like later on, it was discovered there was something that they had lied about. And a judge came back and said, if you didn't care enough to check it out before you hired her, it's too late now. And so keep that in mind. You can't just pick up the dishonesty, flag and wave it at any time. It has to have a purpose. It has to be timely. And you've got to have solid, evidence on that. I've seen where a client had video of a general manager basically stealing. There was a restaurant, and every time someone was ordering takeout and paid cash, she would pocket the cash. But his camera wasn't, it was like probably 15 feet away from the register and wasn't close enough, didn't go enough detail to where you could see her hand going into her pocket. You just knew that every, the evidence he had was that every one of those cash orders got canceled by her after the fact. And, so the odds of that were pretty low, high as far as not being a normal situation. But we couldn't, we talked to the police, and it's like literally without a camera showing the money going into her hand and into her pocket, they couldn't do anything with it. So you have to recognize that when you're talking dishonesty, it's like, make sure you've got something solid. And, and in your handbooks or when you're hiring, do you have some kind of code of ethics? Those are becoming much more popular now. And to look at something like that and understand what your company's ethics are, because some are much more diligent about it than others, or much more precise in, I should say, of what they are looking at as far as the proper ethics for that company. So you kind of want to look at some of that stuff. And our final polling question, they all came in the first half.
Polling question. Employees who come to work under the influence of drugs or alcohol are protected under the ADA and cannot be terminated. Is that true or false? And CJ, we had a question come in. When you were just talking about someone going to jail, you said to tell them you may want to resign to avoid termination. Can we tell people that they should resign? Could that ever come back to hurt us?
You can't. No, you can give them the option. And so, because it's a weird thing, it's like, in the end, you're gonna terminate them anyhow. But there's a lot of employees out there who truly believe, it's almost like they think their employee file is going to move from company to company because they really hate the thought of something in their file saying they got fired, and they will opt for the resignation if given that choice.
Even though that jeopardizes their chances at unemployment.
Yeah, I know. And it's a weird thing, but sometimes they do because they'd rather say they left voluntarily, when they go looking for other work.
Okay. So on this question, employees who come to work under the influence, 15% say true and 85% say false.
Yeah, it's not an automatic protection. There might be something, but normally just drugs and alcohol on their own are not, I'll take that back, are not a protected thing. It's like where the only protection really is, because like I said, even with medical marijuana cards, it's not a protection if you've got a policy that's saying we have zero tolerance and medical marijuana cards are not valid here. And you have that right at this time. And, alcohol, there are at a certain size company, some of the laws will protect them if they came to you and said, hey, I'm having a lot of problems with alcohol. I need to go into a program. And at a certain size, depending on what state you are and stuff like that, but I know in California, then the company is obligated to give them an unpaid 30 days off for them to go through a program. But it's a one-time only thing. If they don't pass it or if they start drinking afterwards, you can immediately terminate them at that point. But, there's nothing yet that says that drugs or alcohol are a protected characteristic under the ADA. So it would have to be some far-reaching thing that made that happen, because it's, you know, they can't say, well, I've got this disease and have to take drugs, because if they're being fired for drugs, it's probably because they're abusing the drugs, not because they're merely taking it for treatment. And so that's where you got to get some clarity on that, that they're over the top, they're not behaving normally. I know in my handbooks I often say that if you're on, you know, particularly a short-term prescribed drug that has a little warning list in there, because some of them, a lot of them actually will say you should not operate, you know, heavy, you know, machinery, or shouldn't be driving while taking this prescription. It's like I put in there, it's like if you've got anything that's going to, you know, alter what you can do at work, you need to let your supervisor know. The employee doesn't have to tell you why they're taking it, as long as it's a prescribed drug. They merely have to tell you this, I'm taking something, the treatment is going to be for 3 months, but it says I shouldn't be driving. So now you're looking, you know, asking for a note from the doctor requesting modified duty or something like that. But it's better you know that than they get in an accident because they're taking it and didn't tell anybody. And that goes back to how you explain your policies and make sure they understand that. But the ADA just, you know, it protects a lot of different things, and a lot of things that you can't even tell is wrong with the employee, as far as that they've got this or that. But the way the ADA is being written, and that bar that got lowered, it needs to alter their life, but it may not be visible to you. So you need to kind of look and ask questions if you're doing this, but most of the time just normal drug and alcohol termination isn't going to be protected, but you do need to ask questions. So and this is where you go, if the workplace safety is endangered, so you've got, you know, drug and alcohol policy violations, which often can be a workplace, you know, safety issue. It's like somebody comes in a little tipsy from lunch, or that they just drink in general, they're on drugs, or, you know, it's like I had a client who wasn't actually a client. It was somebody who I was talking with about being a client, and then I found out he had illegally done company-wide random drug testing, which in California you can't do. And he was unfortunately surprised by the results. I've seen companies that want to do like a company-wide, but they're really only targeting one employee. And, you know, and it's like they could actually go do the one employee without a problem, but they can't do a company-wide just off the spur. And they got back and they had like a sales rep who had been with them a long time, who was a meth addict. And he flat out told him, he goes, I'm not going to stop. Do what you had. And and so I talked to the company about that. You know, you've got, he also found out he had a couple of employees who were, had been doing, smoking marijuana. And one of the employees, when he talked with him, said, hey, you know, I smoked the last joint on my way to work, so I don't smoke while at work, and thought that was okay. So it's an interesting kind of thing when you listen to what's going on in the employee's mind about some of these things. But in the end, recognize the company is the one who will always take a hit on this kind of stuff. You know, even when you have company parties and things like that, the company is responsible for anybody who has an accident out there because that you provided them a drink at a company party, things like that. So you've got to be careful about that. Reckless behavior, somebody just, you know, showing off and doing something stupid, falls off a ladder or knocks somebody else over, you know, that's a problem. Threats and intimidation, that's been like on the list for a long time, but it's taken much more seriously now because of, I think it really started with like school shootings and stuff, to where now, you know, any form of violence is taken extremely seriously, and, you know, inside companies, and is cause for immediate termination. But again, training, you've got to make sure people understand that. And, you know, and if you're not going to terminate, then you have to, you know, I mean, in any case, you need to document and look at that. I actually recently had a workers' comp case with a client where it was a safety issue, where they were doing something in a stairwell. And so they had one of those weird ladders that does those kind of C shape and, you know, stuff. And there was an employee holding on to one side of it to steady it, which is their safety protocol. Another employee told him, it's like, hey, you're holding it on the wrong side. You know, for safety purposes, we're supposed to hold it over there. Well, they ended up kind of going back and forth till finally the guy holding the ladder stopped holding it, shoved the one guy against the wall, down under the stairs, and, you know, and it's like, whoa. And during this, the guy that got pushed down on the stairs then had a workers' comp because his back was hurting. And talking to their workers' comp carrier, there was actually a clause inside the policy, and the contractor or the workers' comp policy, that said that if an employee initiates the incident, they will be denied the workers' comp. And I'd never heard that before. And it's like, whoa, okay. So there's like a lot of little ripples in the pond when you're talking workplace safety. So pay attention to what you've got out there. You can't fire an employee if they're seeking help for drug addiction and alcoholism. And I won't say that's a given in every state. So make sure that you know whether or not that's true in your state. That you can't fire them if they're complaining about safety issues, no matter how much that might irritate you. You can't fire them if they're cooperating with OSHA inspectors, because I've seen employees, usually it's ex-employees, so that call up with an OSHA complaint and they start that ball rolling and then they're off in the wind. But if they were an active employee, you have to just disregard that, because then it looks retaliatory. You can't fire them if they're refusing to perform a dangerous job that puts safety at risk. And so kind of, again, look at what your safety protections are, what your safety protocols are, and whether or not you even have a safety plan. When we look at the language, and this year we've seen, I think, more language than normal for different types of breaking of the employment relationship. We've got the involuntary. That means the company is initiating it. Usually they're fired, they're laid off. And to me, I'll describe what I consider the definitions for these. Fired is, yes, you're terminating them usually because you've got a specific reason out there of something that they've done. A layoff legally implies you plan to, that you're not needing them right now, and therefore you do plan to maybe hire them back when things change and you can use that type of person again. But I do find a lot of companies like to use layoff instead of fired because they find it an easier conversation. But it comes back to bite them sometimes because they weren't clear on why that person was let go. You got reduction in force, which is kind of part of a reorganization. Something's happened, and we've seen that a lot in this first half of the year, where now we're reorganizing. We don't need 50 people anymore. We've found out we can actually do quite well with 30. And so there's certain, it's a reduction in force, but it's part of a reorganization typically. And position elimination. Now, this is one where I get people that tell me it's a position elimination, but my rule for it is if you're eliminating the position, so it means if you've got an admin assistant, now you're eliminating that, I don't want to see another person doing that type of work for at least 6 months. Because otherwise it looks like it was just a reason to get rid of that person and they were trying to take the easy way out by saying it was like, oh, not needed. And I just went through that with a CPA firm I work with. And it's like, well, no, these were kind of 2 marketing positions. We're not really doing the marketing anymore, so they don't need that and don't expect it to, rehire. So kind of look at that. It's truly a position. It's not a person elimination. It's a position elimination. And make sure it truly is going to be eliminated. And, because otherwise it's maybe a reduction in force that you had 7 admins, but now you only need 3, but that kind of goes in between the lines there. The voluntary, is the resignation that you get with or without some notice. And, a 2-week notice is not legally required. If you require it, then, and somebody does it, keep in mind that if you change the date in a resignation to something else, you have just made that person eligible for unemployment because now it becomes a firing. They can walk off the job more often than not. You see that where they just either that or they didn't even come to work. The job abandonment. With job abandonment, be careful. Make sure you've got a policy that states what your rule is for that. 3 days seems to be the common where it's no call, no show. So if they're texting you each day, that's not job abandonment. You have heard from them. These are the people you just disappeared. And, and to me, it's like day 1, you're probably checking on them. By day 2, I'm stopping. I don't check on them anymore. It's like if they're not getting back to me, I wait it out until we can just go ahead and terminate for job abandonment. And see what that means, in your state as far as what the rules are for final paycheck, stuff like that. Layoffs, reductions in force, reorganization, you need a business reason. It can't be, again, just the person. Otherwise, it's you firing him or, or not. But a business reason, you're looking at the timing of the notification to provide, especially if you're doing a reorg or a reduction in force. There are some states where you've got this WARN Act that says that if you're terminating a certain number of people or a certain percentage of your company, you need to send out these WARN notices. And I know I've seen them where you have to send it out 60 days in advance. Now, in California, that actually was one of the few changes that happened because of COVID. They're going, well, normally if you're going to like completely downsize your company here because of COVID, we would require you to have a 60-day notice. Well, nobody was able to do that. So now they're kind of like, well, just as much time as possible, which really came down to like maybe 2 or 3 days before everybody was gone. So make sure that you know what the law is for your location and whether or not you have to give a certain amount of, legally required to give a certain amount of notice. And if not, then it's just a matter of, okay, what makes most sense. Also be very clear on what pay and benefits are due employees. And, I've seen everything. I've had a client who was a biotech that was like basically running out of money. They were waiting for some money to come in, but so far it had not arrived. And so I was talking to the CEO about, what the options were. And she said, well, we want to kind of go ahead and terminate everybody, but, it's like, if this money, it's like it would have this thing, and she hadn't even thought about the fact that they had stock options. And as soon as they terminated, they had to buy their stock options or give them up. And so she had to go back to the board and change that whole policy, or the contract they had for their stock options before they could go through with the terminations. And it was set up to where like, all right, if we get the money by this date, this is what's going to happen. But keep in mind, because I've helped companies close down, it's like there is no COBRA if you close down, because COBRA is letting an employee stay on your insurance, but you have no insurance if you close the business. So think about some of those things that might pop up that you just don't normally give any thought to. Look at every possible benefit that they've got and make sure that it's happening. I know when COVID started and so many layoffs were happening, and furlough was the first time that really came up where people were talking furloughs. But the California Labor Commissioner, not immediately, but a couple of weeks into it, said, we believe if you're going to furlough someone, you should pay them out just as if they were being terminated. So that was the one thought with being furloughed, was that, okay, you don't have to pay out that vacation that might be owed them, something like that. But then the Labor Commissioner said, no, I think you should go ahead and pay that out. So now there was like virtually no difference between a layoff and a furlough in California, except for the fact that you still had them on the books as an employee. You hadn't done the final termination. So for some of my clients that had done the furlough, when they realized that they either, the furlough had gone on long enough, or they couldn't hire most of the people back, now they had to go through the actual steps of finishing the termination at that point. And if you're doing layoffs or a reorganization, anything like that, where there's several people going to disappear at once, you need to talk with the surviving employees, because some of them will have guilt about why did my friend get laid off, because they've got to now talk to that friend. And, it's a sensitive issue. It changes that relationship. I actually, years ago, actually it was it wasn't my very first client as a consultant, but it was a company that was, it was my first client. They were doing this was like 14 years ago, they were doing student loan consolidations. And then the law changed and they couldn't do those anymore. And what they also found when I first started working with them was they were working in the red, because they'd hired people and they'd started the company at like the busy season for them. And now it was like in the fall, so it was in spring when they'd hire all these people. Now in the fall, they're talking to me. It's like, we're in the red every pay period. And it turned out they'd held on to all those people. And I'm like, why? And he was like, you can terminate them. He didn't even know you could get rid of some of them or hire seasonal employees. But what was funny was I was the one that got the fun job of having a group meeting of 7 people to let them know they were going to be laid off. And the CEO was out there talking to, we'll call it the survivors, letting them know the future plans of the company and stuff. And when I come out, I speak with the CFO because the meeting's still going on. And I said, what did he say about that? And she said, he hasn't mentioned it yet. And then he ended up coming and sitting down without ever mentioning the 7 people out of like 25 were just laid off. And I had to get up and make that announcement to them. And so you've got to plan it out. What is it you're doing, particularly when you're doing, a big layoff. Like I said, the pandemic was a whole different kind of thing. Everybody understood what was happening. It was just a question of whether or not the company could keep going and they could hold on to their job. But normally a layoff or a reorg has financial backing as far as it's the reason, the primary business reason. But then you also need to, have a valid, non-discriminatory reason on why this person was picked over that person. Stuff like that, so that you can show why these were the people that were laid off versus the other employees who kept their job. And so make sure you go through that and look at it. And overall, before you terminate, consider all the different things. There's a lot of things we've talked about. Is there an at-will agreement, in the state? Is there an employment contract that somehow promises them the job? How long have they been in there? How long have they been employed versus how long have they been in that particular job? Are they protected class? Is there a violation of a public policy? Is there a co-employer relationship? You see this a lot when you've got leased employees or temps that you've been using long-term. It's considered a co-employer relationship. And do you have obligations under the WARN Act to give a certain amount of advance notice? And then you want to look at the other things, is this job being replaced, or the person being replaced? Because that's certainly going to eliminate position elimination from the ability, using that. Do you have a history of complaints from the employee? So it's going to look retaliatory. If you did have an employee who made complaints, what were the company responses? Because a lot of times I see where EEOC has come in and filed lawsuits against companies because they weren't responding properly to employee complaints. They were just terminating them to get rid of the complaining employee. Is there a perception of a hostile work environment? Is this going to be a surprise to employee? I have found a lot of times it is, and my ideal to prevent problems going forward is that it's not a surprise, that they've been told at some point, the words have come out of your mouth, this may result in termination, or your job is at risk. We need to change this. If you don't say those, they walk away thinking they've had a bad hair day, and they don't take it seriously. And then it becomes a surprise when you do terminate. So we want to look at what paper is in the file. Is it helping you or hurting you? I've gone, when I worked inside and I'd have a manager, usually it was like in the first week I'd show up and the manager would come in and say, okay, I need to fire this person. They're just not doing a good job. And I will pull out their employee file, and all I've got is an evaluation that gave them the medium, like a 3 out of 5 on that. That was 2 months ago. And I said, no, based on this, we don't have anything that says they're doing a bad job. So now I will make the manager do their job. You need to, start talking to the employee, trying to improve them, documenting it, and make sure that we've got something there that's not going to work against us. Because if all I've got is good stuff in the files, they're going to, they can ask for a copy of that. And the attorney certainly will ask for a copy of that. You don't need that working against you when you've got so many other possibilities out there of things that happen. And now I've kind of talked about going past my time. So you'll get, you need to look at the fairness. Is this something that you are being, equal across the board on how you treat the employees? Have they been given the due process of looking at that? Was there facts? And, this is a lot of stuff I've talked about throughout. But to take a look at some of those things, and I know you'll get a copy of these slides, so I'm not going to let you sit here and read detail. But look at some of these things. Did you talk with an employment attorney? Is there a severance involved? Is there a separation agreement? I've had most attorneys that tell me you don't give a severance without a separation agreement because you're trading the protection to the company over the money you're giving the employee. Final pay, make sure you've got what's legally required. Is there a bonus payout pending or due? Look at your bonus plans if you've got one. Is like, did the employee, if you've got a payout that comes months later, were they there and therefore would have earned it, or do you have something that says they had to be working on the day of the payout? Is there some kind of benefit continuance or outplacement assistance that you might be providing? You've got a risk assessment. So you're looking at the workplace violence. I actually had somebody who told me they had some employee had recorded this on their phone and as a little video, and but I didn't hear about it for a month, in which case it was too late. But a manager had actually punched an employee in the stomach, and it was recorded in video. And a month later now he's trying to fire the employee. And it's like, you got to be timely with these things. You can't just pull it out of your hat that says, in 1997, this person did that, so now I'm going to fire them. Even with attendance issues, if you've waited 6 months after giving notices and they're still doing it and you didn't do anything, you got to start over. Some kind of security, IT, what are the risks there that they've got access to things? What do they have that belongs to the company? Do you have any kind of confidentiality or proprietary agreements in place? And sometimes it's in your handbook and that's sufficient. Look at, what kind of interactions the company's had with that employee. And look at the company reputation, because if you've got a termination that doesn't seem fair to the employee, they're going to raise a stink about it. And if you're a public company or looking to go public or looking to be part of a merger or acquisition, that can really come back to hurt you. And because I've seen where in mergers and acquisitions, they will back away so fast if they find that there's an employment claim out there that's still unresolved. And so you need to kind of look at some of those things and figure out what's the risks for us if we go through with this termination and what are the alternatives. So you want to think carefully before deciding to terminate. I don't mean you take 4 months to think about it. I do think that once you've got all your ducks in a row and you've talked with legal counsel if that's necessary, you move quickly. I don't know how many times I have had somebody say, yeah, what is today? Tuesday. Okay, yeah, we're going to meet with the employee on Friday or next Monday because Sam's on vacation this week and we want him to also be in the meeting. And then, so they've got it scheduled in their minds on Monday, and Monday morning I get a call. It's like, oh, the employees just filed a workers' comp claim, or the employees just told us they're pregnant. I cannot tell you, it's a large percentage of this happening. It's because employees have this second sense that something's going wrong. And if there's a reason they can come up with that will protect them, they will use it. And you do it in private. You don't, in private. You do not bring in other employees. You bring in, if you need to, like I will always make sure the manager's there with me if at all possible. So it's not just me, because these days you want a third person, but you don't do it out in public saying, oh, you're fired. That's not the way you do it if you don't want problems. It helps to have, with HR, I think it makes a difference if it's helpful. I know if I'm called in, I've got clients that will say, can we have somebody here for the meeting? And I do know, even when I worked inside, if I am part of a meeting, whether it's a disciplinary meeting or a termination, I've ratcheted the anxiety level up considerably just by me being there, even if I don't say anything. So kind of do that. But I've also had security. I've hired, the security that's private investigators often have access to security people, or they are the security people, and they will kind of either be in the room with me or outside if there's a potential for violence. And, sometimes it's good to have an exit interview. It kind of depends. It's amazing sometimes what comes up in that, but I have found unless your HR is truly trusted by employees in general, it sometimes is better to mail, including a stamped self-interest envelope, to an exit interview, a written one that the employee will fill out, because maybe they'll say something in writing they wouldn't say face to face. And as quickly as possible, you need to let employees know. And you don't say, oh, Sam was fired today. You kind of say, instead you flip it around. It's like, Sam is no longer with us. And, here, Joe's going to take over his duties, or we'll be, back in touch. If you've got external customers, and I see this a lot with sales reps, you want to be on the phone, have somebody on the phone with them as soon as the meeting's over. And you kind of say, Sam, won't be your rep anymore, but, Joe's going to be, here's his, I'll have him contact you within the next couple days. And you don't go into details about why they're fired or why they're left at all. You just say, no, it was, and sometimes if it's a mutual agreement, which sometimes it can be, you talk with the employee. How would you like us to address this? Because sometimes they resign for different reasons, or you're terminating, but it's not necessarily a big negative meeting. And, and you both come to some agreement. It's like, okay, why don't we, say this? And you kind of have a script that both of you are following, that, it was just like mutually agreeable, because it might be somebody that, was still a nice person, things like that. You don't want to just throw them under the bus, but you also don't want to make it sound, necessarily like they left because you were a sucky company. So you need to kind of find some common ground that you can both use that's acceptable to both sides. Okay, talk fast those last few minutes, and sorry I've gone over. Other questions?
There are a lot of questions, CJ. So I'm not sure if everybody's willing to stay on for a few minutes, or if we should answer the questions by email. CJ, what is your time restriction today?
I can stay on for a little while, so let's see if we can get through some of them.
Okay.
See where we are.
If an employee's job is driving for the company and they get a DUI, they're no longer covered under our company insurance. Is this grounds for termination, or would we be best to move him into another job that does not require driving?
That it would be grounds for termination in my mind, because as long as, and make sure that on the job description, you have put that they must be eligible to be covered under your company insurance, because that gives you all the backup you need.
Okay. So employees usually know when a separation is coming, and they file a complaint against a supervisor. So what is the best practice to avoid a retaliation claim if separation occurs?
Well, ideally, you go through the complaint first and deal with it, and kind of figure out whether or not it's valid, how in what way it affects the employee at all. It may be that it was just that they, he complained about it, but it wasn't really affecting him, or the reason for your termination. And I've had a couple of clients where they were in the middle of a discrimination claim by that employee, but they decided to still terminate because they felt that the employee would cause more damage by staying than they would get by the look of retaliation. But you want to kind of know what it is. In that case, it happened to be more that it wasn't necessarily directed at them. It was things they'd witnessed. Okay. So you kind of want to look at that claim first.
All right. And for those of you who are not able to stay on, this session is being recorded, and you can request a copy from Heffernan after the session today if you do have to leave. We'll continue with our questions here. If you are forced to resign, do you have to admit that on a job application?
No. It's like, I think mostly you flip it around. I know employees are very worried about what it says in their record, but most companies are not willing to share that information with whoever you're going to interview with. And so, that would be one question when you're being, if someone's being terminated, or if you're doing the termination meeting, you tell them, here's what we will say. And the only thing we will do is provide dates of employment and your most recent title. We won't say anything else. And if they know that, then they're free to say whatever they want, as long as they're comfortable with that.
Okay. If you have a problem employee that, just shows just kind of lack of attention or frequent absences, things like that, and then you terminate them and you give the reason that you're eliminating the position and you give them severance, do you have any
red flags? Yes.
Yeah.
Yeah. It's like, okay, so you want to be at least consistent. It's like, it's one thing to terminate for their poor performance or their laziness. I mean, I've had to have those conversations, is that, and part of that is, again, are you giving them a heads up? It's like, you're not making an effort here. To me, that's like the classic thing. First, you put them on a performance improvement plan. But I always make sure that mine have a lot of little deadlines in them. And as soon as they start missing a couple of those little deadlines, I'll have a meeting and say, it doesn't appear that you're even trying to get better at this. So I don't see any reason for us to continue with the plan. And we're just going to go ahead and terminate. But if you're saying it's a position elimination, then it doesn't matter about the poor performance, but you better make sure that you're not going to have that role in your company for quite some time in order for that to fly. Because, and I see that used a lot when they know they don't have a good reason for terminating somebody, or it's somebody who's older and they're just saying, oh, we can live without that position. But then they hire the role and give it a different title. And that is still not going to fly if it goes into court. If that employee files a lawsuit, it will come out that you just relabeled their role and gave it to someone else.
All right. So I know you touched on this, but we're still having a few questions come in. Can you terminate someone during COVID?
Oh, yeah.
Their COVID
Why not?
leave. I'm sorry, during their COVID leave, if they're on furlough.
Oh, the furlough offers no particular protections. I mean, the furlough meant it frankly, because even if you look at the way the laws came in on protecting people with COVID, they said that like the federal emergency, the Families First money and stuff like that, it was not available to anybody who had been laid off or furloughed. They had to be actively working even to get that paid money and that little bit of protection. So it's like if they're furloughed, it's more, that's where, because you furloughed them, now you have to go in and finalize that termination. And I think the easy thing there is just to say, it's now been several months, much longer than anybody had planned. I mean, originally the furloughs were expected to be, maybe a month. And you just kind of say, it's like, now it's gone on. We really don't know when we might be able to bring people back. So we're just going to go ahead and finalize the termination to give you more freedom to go look around, assuming they are. And I mean, it's not like they couldn't have looked around, but it's a good way to say it. And, just like keep it simple like that. It's like, we just don't know when we're going to be able to hire more people back.
Okay. Does seniority need to be a factor taken into consideration during layoffs?
It's one of the factors. It doesn't carry more weight than anything else, because sometimes you get somebody in there, and most of the time in a layoff, you're looking for, you flip it around in your mind. Look and see why you're keeping the people you chose to keep. And make sure there's nothing there that they were the best performers or something like that. And, but to then look at your list of who got chosen for the layoff and make sure there's actually, you can see, if you go online and search, it's like there's charts that they'll give you that tell you, like, here's the things to consider. It's like, did you only lay off, your older people, the people with disabilities, the people out of certain, protected characteristics? That's where you get into trouble. So the length of employment only matters, because some people who may have had the job a long time have been just floating, and the person you want to keep has only been there a few months but is kicking, and doing a fabulous job, and that would be the one you'd want to try and keep, unless you're going across the board saying first in, first out, or last in, first out. If they were just the most recently hired, then they're going to be eliminated regardless of performance. But often performance comes into it, but you need to be able to look at the fuller picture.
Okay. If a potential employee discloses that they were convicted of a felony on their job application, can you still ask related specific questions during the interview in an effort to assess the safety of other employees?
Well, there's many states now that have a ban the box law, which means that you've had to take it off your applications that whether or not they've had a felony. And you don't get to ask that until you've made a written conditional offer of employment, at which time then you can talk about it. But bottom line is, it's going to need to be, we'll call it job related. You're going to have to show, like, okay, this guy went away for embezzlement and he's looking at a finance position. That would be cause not to hire that person. But if he went away because when he was 20 years old, he stole a car and he's going into a finance position, maybe not, that's not going to necessarily fly. But you have to be careful what your state law is and how you're asking that, because they are pushing hard in most states to do the ban the box, because they found too many people that had felonies. It was becoming kind of discriminatory because they, of what races and stuff like that were being, nationalities were in prison. But also they realized that a lot of companies weren't giving, we'll call it the ex-convicts, a chance at all. And they wanted to at least give them a chance to try and get a job and see how it goes. So you want to be careful how you use that.
Okay. If an employee resigns and we pay them the full 2 weeks but don't require them to work the full 2 weeks, is that still a termination?
No, that's a resignation. It only changes if you don't want to pay them out or if you change the date. Because a lot of times I'll see where the employee gives the 2 weeks notice and the client is like, oh, I don't need him more than a day just to clean up some stuff. And so, the most you can do would be try to do a sneaky attack and say, hey, it's like, I don't need you for the full 2 weeks. If you want to move your date up, I'm okay with that. If they're willingly and not being coerced into changing their date, that's fine. But otherwise, I think as a rule, you just you pay them out if you don't want them there. And that's often better because most of the time they become a poison pill, because if they're going to another job, they're telling everybody about it and making it look like it's so much more fabulous than your company.
Yeah. Okay. If an employee requests a copy of their file, how soon must you provide it? And is there any information in the employee file that can be withheld?
It's going to depend on your state. California has a law, I think it's like 21 days for their employee file. You've got to get that. So look and see if you've got a state law that actually puts a limit on there. It's kind of at your convenience. Don't stretch it out forever because they're asking, and I usually, ask for it in writing, the request in writing, and they absolutely get a copy of anything they've signed. The things that may not be given to them, and this is where you might want an attorney or an HR professional to look through it, I usually am not going to include the little notes that maybe a manager put in that the employee never saw or nothing was done with them, things like that. But there's a lot of stuff that they do get. And but that's why, as a rule, it's kind of nice that if you've got things going in the file, that the employee is knowing about them sooner or later, to where if those notes are there from a manager, then at what point did you write up the employees so they had to sign off on it, that these were issues? If you're never going to write them up, then why are you keeping the notes?
Right. So we still have 5 or 6 more questions. Do you still have time, CJ?
I do.
Okay. Is suspending an employee without pay for 3 days advisable?
Depends on your reason. I do have several clients that are more than happy to do an unpaid suspension based on what the disciplinary action was for. So you kind of want to look at that and see, it is, especially if it was the alternative you came up with to a termination. And, because I've got one company that it's electrical contracting, and one of their electricians that has a company truck, turned out he was drinking on a job site, left early without telling anybody, and he even got pulled over by a civilian somewhere on the road and blamed texting on his phone as his reason. But the civilian called the company, and so when they talked to him, found out he'd been drinking and stuff, and he lost his company truck for 2 weeks. He was put on unpaid suspension for a week, and then on a bigger notice for a longer period of time, a bigger warning for a longer period of time. So it really, you've got to use stuff based on sometimes it's based on your employees, that if you don't want to terminate, because I know a lot of my clients it's so hard to find the employees and train them that they don't want to terminate, but you need something that's going to get the employees' attention. And so sometimes an unpaid suspension is just the ticket for that.
Okay. And so some COVID related questions. At some point during this COVID situation, we're going to have to go back to work, but some employees are already making noises that they won't feel safe regardless of the cleaning protocols in the building. They want to stay home. So at what point can you terminate them, and for what reason? Or how do you address that safety issue with the employees?
This has been an issue really for months now, as far as the employee feeling safety. But I have looked high and low, and I've talked to a lot of people, and bottom line is nothing out there is protecting those employees. So the way we have handled it is that we tell the clients that you can let the employee know that we understand you don't feel safe and that is your option, but we will treat it as a resignation and process it that way.
Okay. If we lay off during COVID due to not having enough work and funds, are we allowed to rehire another person if our business picks up, or do we have to bring the same employees back?
Well, in an ideal world, you're bringing the same people back, because that's kind of the concept of layoffs, is that you are, something like this happened and now things are getting better, you bring the people back. But I have seen a lot of companies kind of cleaning house right now and only picking and choosing the best employees to bring them back. But I will say, at least in California, and I haven't yet seen in other states, but California, and it seems to be more city or county related, but in the Bay Area, they are now putting laws in place there that you must bring back the same people when you're ready to rehire. And because they want to, the people that were furloughed or laid off, you bring those people back. You don't get to pick and choose. If you didn't deal with the employee not being a great employee while they were working before, now you have to deal with it. And, so in theory, you can bring other people back, because I know a lot of places, they consider the layoff the same as just you fired them. But it does raise a few questions, which is why some places are putting laws in place to protect those people. And, and then ideally you want them all back and everybody did their job well. But if they didn't, then you want to look at why you aren't wanting to hire those people back and what could you have done. Because if you've got a certain 10% of your people aren't ones you want back, then what happened that they hadn't been fired before now? So yes, you could. It's not necessarily recommended, but yeah, it happens a lot.
Okay. And is it true that when someone calls to verify employment, as the employer, you cannot tell the calling party the reason why that employee would
you can't.
be fired?
There's no law that says you can't. However, there's a very good chance you'll get sued if you do. So it's more your self-protection that you don't. The only time, because there's no value. I mean, it's unfortunate, because that used to be a great resource for figuring out whether or not you're getting a good employee. But nowadays, the only thing you legally can do without getting in trouble is provide the dates of employment and the title. You don't even give out wages unless the employee is giving you something in writing that says it's okay to do that. And even then, I would maybe check each time you get asked to make sure that asking party is on the employee's list of who they were willing to help know that. Because a lot of states now you can't ask about the previous salary anyhow. But for safety purposes, most companies are only doing the title and dates of employment, and you're on your own, it's like to get other information.
Okay. So another COVID related question. If you have employees that are at risk, maybe because they're elderly or they have certain health conditions, can you eliminate their position as an RIF restructuring, even if they have longevity?
You don't want to do it because of that reason. If you're doing a reduction in force, then, you leave COVID off the table. Look at the other things, why that employee versus someone else. If it's someone who can't come to work, he's got a doctor's note saying, I'm an at-risk person, therefore I'm not allowed to go anywhere. Basically, I have to keep in quarantine or isolation in some fashion. That's kind of a different thing, and it's not really a reduction in force concept. So I don't think you use COVID as one of the reasons. COVID on itself is not a reason for terminating people right now. It's only if you're doing a reduction because of COVID, but it doesn't break it down to the individuals then. You want people who can do the job. So if he's not able, to do the job right now because of personal reasons, there are some people, a lot of people out there that have health conditions that mean that they shouldn't go in to places where there's a lot of people because they've got a much higher risk of getting COVID. But that's kind of different than deciding who should be on your RIF list.
Okay. And what if employees decline to come back until the stay-at-home is lifted?
This has happened a lot, and in California particularly, because in certain states, I know, the federal government gave an extra $600 a week in unemployment to people unemployed through COVID, but it also made it very difficult getting employees back to work that hadn't been previously making a lot of money because they were earning more on unemployment than coming back to work. But bottom line is, if they refuse, it's like across the board, there's no protections for them. If they refuse to come back, it is viewed as a resignation and they should not collect unemployment. California even has a place on their website where you can file it as fraud, because a lot of employees were staying out of work simply because they were getting more money on unemployment, and it wasn't because they were afraid, they just got more money. And so I actually was encouraging companies to file it as fraud, because you'd find out that they'd still, they were doing it for and we even had a memo set up to where we were notifying employees, if you choose to stay home, it will be considered a resignation, and we will be informing the state that you are not eligible for unemployment.
All right. Okay. Just a couple more. If an employee is laid off and offered severance, how long should you give them to return the signed release in exchange for severance?
In some states, you may have laws. In California, if they're over 40, you have to give them 21 days. And then there's an 8-day period, once they've given you the signed copy back, regardless of when it is, from the moment you get the signed copy back, you wait 8 days before you pay out the severance, because they can go in and change their mind. If they are under 40, there are no rules to that. So I typically will provide a 3-day window. And you want to be clear and put it in there, because you don't want it hanging out there forever. But 3 days is enough to show that they weren't coerced into signing it, because I think, I actually don't like someone to sign it immediately, because I don't want it to look like coercion to get them to sign.
Right.
Because they are giving away some of their rights when they do sign it. So it's like, take it home, look at it. If you want to sign it, great, get it right back to us. But you got 3 days before it's off the table.
And what if they don't sign it but request more time?
That's going to be up to the company. I don't know. I think, if it was like you gave it to them on a Friday and you gave them 3 days, I would probably give them a couple more days so they have a chance to at least talk with an attorney, because that's the concept, is they've got a chance to actually read it, talk to somebody who knows what these things say, and then get back to you and sign it, knowing what they're signing. But I wouldn't take it much further, because let's just say there's no good reason to extend it. Because if they've gotten enough time to talk with an attorney about it and they've done that, then fine. But I don't know how it turns out to be a positive for the company to extend it much beyond that.
Okay. And just wanted to clarify something that or not clarify, but confirm something that you said during the session today. If you terminate an employee due to terminating the position, you should wait 6 months before hiring somebody else into that position. Is that what you said?
Yeah, that's my rule. Now, that's not a law, but
Okay.
to me, it's like if you get somebody, like I had a client who was wanting to fire this scientist, and they didn't like, and it turned out it's like they were telling me it was a position elimination, but they had several other people in the position. He was the oldest, and it turned out they just didn't like him. He didn't get along well with others, and yet, they wanted to call it a position elimination. It's like, no, that's not what this is. And he could come back and say, wow, this is, there's 5 other people there. Why was I chosen? Blah, blah, blah. And so to me, a position elimination means the company doesn't need that role for the foreseeable future. So you could hire somebody back in like 3 months, 4 months, but you don't want to turn around and find out they're running an ad the next day, because that's going to look very bad for you.
Yeah. So this is our last question, and I'm sorry, the questions keep pouring in, but we actually have to cut them off at some point. So our last question has to do with the fact, it's another COVID question, that companies are making accommodations for employees who have children that are home because the schools are closed. But now that some schools are requiring distance learning for the entire new school year, what is the employer's obligation to continue to work with and accommodate their employees who have kids?
It's still up in the air. I mean, it's like I know I've got one of my employees who has young children. She says, I will do anything to get them back into school, because it's so hard, with the way the schools are doing. It's affecting the employees, and then therefore affecting the companies. There is no clear answer out there right now on what companies are expected to do about this, because we have the emergency, family leave for childcare purposes that was covering them for up to 12 weeks, but it's going to be longer than that. And there just are no solutions. I know some of them are coming back. I think in some cases, with the schools, the distance learning from the people employees I talked with when the school was still on, as distant learning, they were going crazy trying to help their kids with the distant learning thing. It was a nightmare. And I think it continues to be a nightmare for parents with kids in school or even in just childcare right now. And there are no good answers at the moment, because I think it's going to come down to the fact that employees either can work or they can't. And I don't know if the feds or somebody's going to come up with some kind of protection for them. But bottom line is, if you've got a field position for a person and it's something that they cannot do remotely, then it really, companies I think won't be required to hold on to them. But it is going to be very awkward and very touchy for a while here until we see where this is going with, you know, who's going to start in class school, you know, school versus the distant learning. It's a mess out there, and I don't think anybody, and that's kind of what the feds are working on and the states are working on, trying to figure that out. But in the end, I know a lot of my clients need the employees on site somewhere in order to function, and they won't be able to handle, you know, because even now we know there's only certain positions that do remote work well or can be done remotely, and the rest can't. So there is no easy solution here.
Yeah, it sounds like we could have another full webinar, maybe a 2-hour webinar on
like the crazy COVID webinar.
So thank you for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. And thank you, CJ Westrick, for your time and expertise today. And we hope all of the attendees found today's webinar to be a valuable use of your time. And be sure to join us on August 18th for Employee Handbooks, Do's and Don'ts. Thank you, everyone, and have a safe day. Thank you, CJ.
All right. Bye.